Hi guys, so let's start with case study number 53 MCQ first. The cost of the flats offered for sale by UBDL was 50 lakhs. How much advance UBDL can take from the customers without entering into written agreement? Okay, so this type of question has been asked in a lot of case studies. Okay, so maximum amount of advance that can be accepted by promoter is 10% of the cost of the flat or apartment. So here the cost of the flat is 50 lakhs. So the advance that can be accepted is 10% of 50 lakhs is 5 lakhs. Okay, so option B is the correct answer. Next, what is the effect of registration of transaction of creation of security interest by a secured creditor under the Central Registry of Securitization, Asset Reconstruction and Security Interest of India? Okay, so for this we have to refer the legal provision. So as per section 26C of SARFAESI provides that without prejudice to the provision, etc., etc., so any registration of transaction of creation, modification or satisfaction of security interest by a secured creditor or other creditor or filing of attachment orders under this chapter shall be deemed to constitute a public notice from the date and time. Okay, so it shall be considered as public notice. So when this kind of transaction is registered with CERCAI institute, then it will be considered that you have given a public notice. Okay, so option D is the correct answer. Next, third, the following particulars of creation, modification or satisfaction of security interest are not eligible for registration on CERSAI portal. Okay, so for this there is a RBI circular which says that. Okay, so RBI wide its circular number this Government of India has issued a gazette notification dated Jan 22 2016 for filing of following types of security interest on CERSAI portal. So all these four transactions or all these four types of security interest are eligible. Okay, so you have to file for example, first, particulars of creation, modification or satisfaction of security interest in immovable property by mortgage other than mortgage by deposit of title deeds. Okay, next, particulars of creation, modification, satisfaction of security interest in hypothecation of plant and machinery, stocks, debts including book debts or receivable whether existing or future, particulars of creation, modification or satisfaction of security interest in intangible asset being know-how, patent, copyright, trademarks, license, franchisee or any other business of commercial right of similar nature, particulars of creation, modification, satisfaction of security interest in any under construction residential or commercial or part thereof by an agreement or an instrument other than mortgage. Okay, so all options are eligible for registration under CERSAI portal. Okay, so they are asking who are not eligible. Okay, so these so if I have to be honest, I also don't know the logic behind the answer, but considering it is based on RBI circular and I am going as per the ICAI answer, so option D is the correct answer. Next, resolution professional constitute a committee of creditors who shall be entitled to become member of COC. Okay, so as you know, committee of creditors are formed with financial creditors, and if financial creditors are not there, then we will consider the operational creditors. Okay, so we have to see whether in this case financial creditors exist or not. Okay, so let's see. So as you can see from here, so unique builder has started the construction work and they raised a loan on the land of rupees 20 crores from ICICI Bank. Okay, so they have raised a loan of 20 crores from ICICI Bank. So there is a financial creditor, so ICICI Bank will become member of COC, as well as it has been given that UBDL, that is Unique Builders and Developers Limited, took a booking amount of 8 lakh from each of the allottee. The agreement of sale was executed with all the allottees within a period of 1 month from the date of receipt of the booking amount. Okay, so as and when the booking was started, so here they have given that on the very first date when the booking was opened, all the flats were booked. Okay, so here the allottees will be considered as financial creditors. Why? Because the 8 lakhs given by them would be considered in the nature of financial debt, and they will be considered as financial creditors, and both the ICICI Bank as well as home allottees would be considered as financial creditors, and both would be member of COC. Okay, so option D is the correct answer. Next, after the transfer of the new project, the new promoter intend to do some minor changes. Okay, so can he do so? Yes. So after reading this question, you have to quickly think of the provision which says that if there has to be any changes in the structural changes, then 2/3 of the allottees consent has to be taken, but they have given that there is a minor change. So for this, let's see what are the options. So it is not a very important or major change. There are some minor changes that the new promoter wants to do. Okay, so can he do so? Yes. So for this also, option D is the correct answer, because minor changes as per the recommendation of architect can be done after proper declaration and intimation to the allottees. Okay, so for minor changes, a consent of 2/3 allottees is not required, but if it was a major work or major structural changes were going to take place, then their consent would have been required. But since it was these are minor changes, no such consent is required, and minor changes as per the recommendation of architect can be done after proper declaration and intimation to the allottees. So option D is the correct answer. Okay, so we have completed case study number 53. Thank you.